It would be just your job to ensure that the client is kept up to date on the progress. The same can apply for even the lease matters. In remortgaging, you would just have to make sure that all of your queries are satisfied for the lender. We now move on to stage 4, exchange of contracts. Before the parties can exchange contracts, the following requirements have to be met. From the purchaser side, they require the signed document, known as the contract, 10% of the purchase price. For example, if you're purchasing a property for 600,000, you would require 10%, which is 60,000. And you would need a draft building insurance policy. From exchange, the purchaser would be liable for any damage that happens to the property. So therefore, the policy is a must for their benefit. From the seller side, you just require the signed contract. The solicitors who act with the purchaser and seller, they would have to communicate with each other on the agreed exchange date, and once they have exchanged contracts, they would also have the completion date. After this has taken place, from the purchaser side, you would speak to your client and inform them to remit the rest of the completion funds onto your client account. If they have a lender, you would also contact their lender and request the funds to be remitted by or before the completion date. And on the sale side, you would be requesting a redemption statement if the property has a charge on it. Following exchange, the legal time clock starts ticking and both parties are bound by the contract. If for any reason the purchaser fails to complete, then they lose their 10% deposit, the 60,000 which I gave as an example earlier. And now we embark on stage 5, completion. From the purchaser side, you would be obtaining the funds from your client and the lender, if involved. Once you're in receipt of all the completion funds, you would remit this to the seller solicitor's client account. You would then wait for the seller solicitors to give you a call to confirm receipt of the funds and to formally complete this matter. From the seller side, you would have the funds reaching your client account, and once they have been received, you would then pick up the phone and give a call to the purchaser solicitors and then complete this matter. From the seller solicitor's point, they would also have to contact their client to release the keys, and in case it's not their client, any nominated third parties, such as estate agents. However, if you're in a situation where you have not completed on the proposed date, the seller solicitors have the right to serve on the purchaser solicitors what is known as a notice to complete. This would force the purchaser to remit the 10% deposit immediately to the seller solicitors, and the seller would then have to wait 14 days after the completion date to complete this matter. 14 days is the amount of time that is available to the purchaser to rectify this fault. If the fault has not been rectified beyond the 14 days, the matter will then collapse. Largely speaking, these are the stages that are applicable in both private and commercial conveyancing. But this is not the end. There are post-completion steps to be taken on board. We now enter the hidden stage 6, post-completion steps. From the sales side, this would be just simply redeeming any charge that is on the property. However, from the purchaser side, the following steps have to be undertaken. The first is filing with HM Revenue and Customs the stamp duty land tax return. This would confirm that the purchasers have just bought a property. Same would have to be done even with the lease matter. After this, you would then submit an application to HM Land Registry, who keep all the records of all the properties in England and Wales. You would file with them the transfer form, updating the records to show the new owners who are the purchasers. This would also have to be conducted if there is any lease that is for more than 7 years. Once these applications have been submitted to the Land Registry, the solicitors would have to wait for the title deeds to return, and thus this would conclude the matter. This is what conveyancing means under English and Welsh laws. I thank you all for listening to me, And I also thank World Law Alliance for this opportunity to speak at this conference. If you have any questions, you can always speak to my team who are on the ground. Thank you.
So that's quite convenient. All right. So, ladies and gentlemen, now we would like to start a new topic, and the topic is global investment, climate, and India's position in pertinent topics such as cross-border taxation and flow of trade with EU, for which I would like to invite on stage Mr. Ravi Bhatia. He has been the managing partner of the Bhatia and Bhatia Chartered Accountants with an aggregate professional experience of 46 years. He is presently the co-chairman of the Banking, Financial Services and Insurance Committee of the PhD Chamber of Commerce and Industry, as well as the knowledge partner for the Export Promotion Council for Handicrafts. Please, let's give a huge round of applause and welcome him.
Thank you so very much, and good afternoon to all of you. I think after the lunch session is one of the most difficult sessions I've ever attended during my 47 years of practice. People either are dozing, either they are sleepy after a heavy lunch, or they are asking so many questions that one tends to forget how many question-answer sessions have taken place. I must thank the World Law Alliance for inviting us here to be one of the knowledge partners in this seminar here in Dubai. My son, Anant Bhatia, who is a partner of Bhatia and Bhatia, he was to come here and address this session. But unfortunately, due to some unavoidable circumstances, he couldn't come, and I got my ticket booked day before yesterday night and came here yesterday morning. I think after seeing the previous presentation, I think he could have also sent a video presentation from Delhi. 2-3 lines about our firm. She has already spoken. Our firm, we are based in New Delhi, India. We are into audit and assurance services, then direct and indirect taxation, due diligences, forensic audits, and mergers and acquisitions. The topic which has been given to us is global investment climate and India's position in pertinent topics such as cross-border taxation and flow of trade with EU. While I have been sitting here since yesterday, I have noticed that there have been so many discussions on various topics like international tax, trade and investment, mergers and acquisitions, insolvency and restructuring, blockchain, immigration laws, employment laws, intellectual property laws, international arbitration and mediation, and only 2 or 3 topics are to come in the subsequent sessions like maritime laws, fintech, blockchain, and cybersecurity. I find all these laws very, very interesting, and I must admit that by sitting here, part of my knowledge has been enhanced, and maybe yours also, because the law is ever changing and is ever evolving. You are all aware that after the COVID pandemic, things have changed a lot. As we were discussing earlier, people earlier used to meet their clients or their counterparts with personal meetings, but after that the Google Meets, Zoom Meets, so this meet, that meet, whereby meet, so many meets, and the whole system of meeting, discussions, and settlements have undergone a sea change. The global investment climate has also changed a bit. As you're all aware, India is at a very, very emerging state at the moment. Our Honorable Prime Minister, Mr. Narendra Modi, is one of the persons to be reckoned with. He is very dynamic, very pushing, and besides that, he has a very clear vision of India 2047. That will be the 100th year when we attained independence from the British rule. Now, his vision, as far as the country goes, is manifold. He wants the investment of the global counterparts to be brought in India, to be improved, and for which I have noticed that many laws have been repealed, many laws are undergoing a change, and many laws are being simplified to an extent so that the global investors find it very, very simple, and it's called the ease of doing business in India. Maybe in one or two cases, people felt, the Indian people felt that the ease is not there, the paperwork is there, but what he sees from the other countries, what his team is learning from the other countries, it's all being implemented in India. And at the moment, the investment climate, in my opinion, is on the rise. I have a small presentation, and how does it work? It goes from, yeah. देखना है क्या हुआ है? अच्छा इसको ऊपर वाले को करना है? Thank you. The global investment climate depends upon various factors. Post-COVID, there have been a lot of disruptions in travel, in investments, in financial markets, and there have been a lot of upheavals. There have been reduced demands. There have been increased unemployment because work from home culture was not appreciated by many companies, so they went into the employment being reduced, and there were increased risks also. There were technical disruptions, like artificial intelligence has been increased. There is need to continue updating everything. And as we understand and as we see every day, the global markets are being updated every now and then. The global intelligence is also being updated every now and then. There have been regulatory changes everywhere. There is some stress going on for the Russian-Ukraine war, and for which there is some fuel crisis in UK or in Europe. All these things have led to some disruption somewhere. But the economic outlook, as we see, is really very good. The interest rates in India are at an all-time high. The inflation is controlled and the GDP growth is increasing. This is also a very, very important and a key indicator for any investment opportunity. There are countries, I don't think there is anybody here from Sri Lanka or from Pakistan, where there is a turmoil going on since last 1 year, and the countries are in some financial mess. So investment opportunities there will certainly not be as much as they are in other countries. Then technology plays an important part. If the country or a place is able to provide technology, it will certainly be a very, very attractive investment opportunity. And if there is an emerging market, like India is a growing economy at the moment, so it is one of the wonderful economies at the moment. There are 2-3 sectors which are growing at a very, very fast pace, like renewable energy. It has seen a tremendous change in the investment in renewable energy. There is a special ministry which looks after all these investments, and the country is into solar power energy, wind energy, this type of energies, besides the other hydro or the different energies which were earlier there. Then healthcare is one of the most important sectors which is booming in India. People from Middle East, from other countries, from Africa, from other various continents come to India for their medical treatment. I remember one of my cousins who was staying in the US, and he came to India one day and said, I want to get my dental root canal treatment. I said, you are staying in US, why do you want to get it done from India? No, it's very expensive in the US, and here it is cheaper for me, and I'll stay here for about 20 days as told by the dentist, so I'll get my treatment done. So healthcare is one big area which is increasing at the moment. The other area is real estate. Real estate has been one of the key areas since quite a long time. It has been developing. There were few states where there were some problems going on, political interventions, regulatory issues led to difficulties in real estate sector. As a certified accountant firm, we were allotted a forensic audit of a very big real estate firm of northern India by the Honorable Supreme Court of India, where the builder swindled away money of 42,000 home buyers and ran away with about 10,000 crores, 10,000 crores of rupees. He ran away. We conducted this forensic audit, saw where the money had been parked, got some money from there, and now the construction is again in full swing, constructed by a government agency. At the moment, real estate is very booming. The prices are on an all-time high, and all the cities in India are witnessing a real estate boom. However, we have to see, we have to calculate and see the risk assessment and mitigation of risk. There are various risks everywhere, whether it is a geographical risk, a regulatory risk, a market risk, or any other risk involved in any investment. Because this is required to be seen before making any investment and before understanding the investment pattern of a particular country. Then there is this ESG factor, environmental, social, and governance factor, which can impact on any investment. As an accountant firm, we assist our clients to see these risks, understand the risks, and guide them where they can go wrong in future or where they have to be more careful in future. Once you plan to invest, you have to then see how you are doing it, whether it is diversification and or whether it is active management, whether it is how it is going to be impact, what impact it is going to be having on the investment which you are making. If I give you a small example, any person who would like to buy a house, a bigger house for himself where he is staying and he wants to buy a bigger house or an apartment, he will first see what is the area, what is the flat like, what is the cost, how will he fund the cost. So all these factors need to be seen in an investment, and these strategies are required to be placed on a record or in a paper and whatever, and then decided how to go for that investment pattern. Now, India, the other topic was India's position in cross-border taxation. After PM Modi took over as Prime Minister about 8.5 years, 9 years back, he has been very, very particular. I have clients who are situated or located in UK, in USA, and they are now so particular about filing of their returns in India if they are having any income in India, whether it is interest, whether it is income from property, or whether it is some capital gain, or whatever income is thereof. Because the government is now looking into various ways how to plug the loopholes in taxation. DTTA, that is the direct taxes agreements, avoidance agreements, have been entered into with 94 countries as of now. As of today, India has entered into DTAA with 94 countries. It is only to avoid tax, only to ensure that no drug money is moving in anywhere or freely or anywhere, and that the government gets its proper dues. There are tax policies, there are rate reductions every year. On the 1st of February every year, the government presents its annual budget for the next year, financial year, which starts from 1st April till 31st March. Unlike other countries where we have a calendar year as a financial year, and they plan in advance to see how best they can give tax benefits to persons who are investing in India and who are going to be a long-term beneficiary of Indian policies. India's position with EU is very, very strong at the moment. EU is the second largest destination for Indian exports and is the third largest as a trade partner. We have many clients who are from Germany who have invested in India. They in Bangalore, in Pune, in Delhi, in Haryana, Rajasthan, everywhere they are investing. And Germany, I have noticed, I was talking to my friend during lunchtime, that Germany at the moment is one of the main investor of funds in investment proposals in India. And there are a lot of, the presence of the European companies in India is at an all-time high. Every day we get some inquiry from somebody or the other to form a company, to see what are the legal formalities and how to go about all things. So the trade practices are very fair, very, very controlled, and I am sure that in the coming years, global investment climate is going to see a tremendous change as far as India is concerned, as India is on the rise, and the cross-border taxation and other flow of trade with other countries will be controlled, and it will be ensured that there is no untoward, unwanted incident happening. Thank you very much.
Thank you, sir, for sharing your experience with all of us. So our next speaker is Mr. Siddhartha Havelia, who is our Director, Mercurius Advisory Services from India. He's a finance professional with over 2 decades of experience in the industry. He's a strong advocate for outsourcing and has spoken about its advantages at industry conferences and events. He has built a reputation for providing top-notch services and has helped many clients improve their financial performance and achieve their business goals. Please put your hands together and let's welcome him on stage.
Hello everyone, thank you for the wonderful welcome. Thank you all the eminent speakers from the different industries who have actually helped us understand one of the most difficult subjects. I mean, as a layman, it would have been very difficult for us to understand those. So in fact, I had like one of the clients from US who is also an attorney visit our office. And during one of the discussions, we were talking about how COVID has actually pushed us 5 years ahead in terms of technology. And I'm glad that we are touching upon the technology being online and all these concepts today. So imagine there is a bank that deposits 86,400 into your account on daily basis. You need to spend the money, and whatever balance remains unused is taken away. This bank account is known as time. It actually deposits or creates 86,400 seconds into your account on daily basis, and whatever balance remain unused gets wiped off. You cannot borrow time or take loan against it. Time management is like money management. You decide how you want to use it. Master your skills, outsource your weaknesses, says Ryan Khan, the founder of the Hired Group. So remember, you can buy time, but only in kinds. Hi, I am Siddhartha Havelia, and today I'm going to talk about how outsourcing has opened the gates to the next world. The concept of specialized outsourcing is nothing new to us. It has been prevalent since the time human society has evolved. But the modern outsourcing, which we know in the current form, has been prevalent since 1970s. It was the aftermath of Industrial Revolution that the manufacturing industry was shifted from the developed countries to developing countries. Gradually, the shift came over to voice support and then the knowledge-based services. But this did not end here. Rather, it blossomed. There are various factors that became the drivers of this industry. Imagine getting the work done as per your convenience, within the cost you want and the quality you aspire. Earlier, people were finding it difficult to share large files, but now GBs and TBs of data can easily be shared with the use of technology. People can access their data anywhere, anytime with the use of cloud-based softwares. Needless to say, pandemic has actually fueled to the growth of this sector, wherein the concepts of remote working and work from home have been graciously accepted by people. Gradually, money became just one part of the bigger picture as people started focusing on the advantages of outsourcing. The size of global outsourcing industry is more than 100 billion US dollars, out of which US itself contributes to more than 60 billion. It is said that US itself outsources more than 500,000 jobs every year. So initially, it all started with the IT services, which covered more than 90% of the industry, even though it is now important, but its share has gone down to 30 to 40%. Non-IT value-added services have replaced the remaining two-third portion. Various services, across sectors like pharma, healthcare, defense, space, and finance are getting outsourced. Here are the list of most widely outsourced services in today's world. A lot of websites and platforms which act as a facilitator between the clients and the service providers have come up. They act in the same manner as Amazon does. Many companies, whether it be large or small, are outsourcing jobs to developing countries. And that's the industry which I represent. When I started working back in the year 2008, I used to work with various clients, but that remained within the geographical limitation. The outsourcing industry was blooming, and I knew there are clients who require expertise, irrespective of wherever they are based in the world. So what started as an idea amongst two people has grown in a team of 300 professionals comprising of lawyers, advocates, finance professionals, CAs, CPAs, and economic analysts. So we started only with two services, that is accounting and bookkeeping services. But over the period of time, our intent was to provide as much services as possible to our clients so that they can rely for all their business needs on us. We kept on moving one step at a time, enduring one milestone with every step. We started working with the smaller companies and kept on adding industries and services across the path. Today, I can proudly say that we are working with over 2,000 clients, out of which 200 clients are from the lawyer fraternity. We have also added paralegal services and the business development services in last 1 year. But the journey was not easy. It wasn't a cakewalk. People had and still continue having a lot of apprehensions about outsourcing. The first and foremost being only for the large players. People had the mindset that only the large companies can afford outsourcing services and can save upon millions. In fact, what I believe is the opposite. Outsourcing actually helps the business in cutting down their cost and reducing their efforts. In fact, 1 out of every 4th small business is outsourcing services to the experts to keep their business up and running. Security concerns. People are concerned about the security of their data. With the technological advancements like VPN accesses, cloud-based softwares, firewalls, and routers, this concern has become less of an issue. Compliance norms. It is believed that the people in Eastern countries are not knowledgeable or skilled enough to comply with the Western laws. This issue can easily be overcome by hiring experts who work with the international clients and have multi-jurisdictional knowledge. Cost savings. Cost saving, no doubt, holds a crucial part for outsourcing. But is it the only reason why people are outsourcing? No. Domain expertise at reasonable cost has become another big reason why people are contemplating outsourcing services. Remember, you cannot master all skills. Weaken and lost control. People also think that by outsourcing, they can lose control over their business. But in fact, outsourcing actually helps you in gaining control over the core processes, as you can now govern work by laying down well-defined KPIs and KRAs. Different time zones. People believe that there can be a mismatch in the active communication. But remember, every coin has two sides. Imagine, you reaching your office in the morning and have like the completed work just to review it and pass it on or take decisions thereon. Substandard quality. People complain that they spend a lot of time, money, effort, and energies, and in turn, get substandard work. As earlier mentioned, this issue can easily be resolved by implementing KPIs and KRAs. As I mentioned, it wasn't a cakewalk, but we did not allow the hurdles become the roadblocks. I constantly encourage my team to try new things, to gain expertise, and to offer tailor-made solution to our clients. We have cultivated an environment wherein people are rewarded for adding new skills and by upgrading their knowledge by way of further education. We also lay emphasis on various professional trainings and attending conferences so that our team remain abreast with the latest developments across the industry. Affiliations and certifications. We have also ensured an organic growth of our company by adding affiliations and certifications across the industry. We have representative offices in US, Canada, UK, Australia, and Japan. We are the member firms for UTN and TIAG, which is the third largest alliance of the independent accounting firms. We are also the member firms. We are also the members of professional bodies like ICAI, ICAEW UK, PCAOB US, and CPAB Canada. In fact, last year, we were also certified as IRS acceptance agent and are the only ones in the state of New Delhi, India. We are ISO 9001 and 27001 certified company. And finally, with the quote of former Singaporean president, I would like to end my speech. Thank you for being all ears.
So ladies and gentlemen, we are now thrilled to present to you our next block, which we are about to begin, which will explore the complex world of marine laws and their far-reaching impact on trade and security. This powerhouse session features two thought-provoking solo presentations offering unique insights into the prevailing international maritime laws. Without further ado, let's begin. So we have our first speaker of this block, Ms. Faize Tabatabai, who is known as qualified lawyer with a law degree from University in Iran, as well as UK, Southern Plan. She's active in maritime field since 1997. She has been appointed by Malta Foreign Ministry as honorary consultant of Malta in Iran since December 2010. Please welcome her with a huge round of applause on stage.
Good afternoon, everybody. I am an old-fashioned person, so I'm not familiar with the new technology. These 2 days were great for me because I learned a lot. As an old-fashioned person, I'm stuck to the maritime law, which is a very old legal subject. So today I'm going to talk about arrest of the vessels. Yeah, I will be quick. In international trade, everybody wants to have a safe transaction and to secure the claims. When you are dealing in international trade, and if you are a supplier, if you are a trader, if you are a service provider in the shipping field, you think that the vessel are calling different ports, vessel may sink, vessel may be sold, or maybe go for the scrap. So you want to secure a claim when you have a claim against a vessel. For this aim, international trade has a way to secure the claim. So first of all, I want to give a very brief definition of arrest. When we are talking about arrest, we do not mean seizure of the vessel. We do not talk about making problem for transfer of ownership of the vessel. When we are talking about arrest, we simply say that making restriction for the movement of the vessel. It means that vessel cannot move till the owner provide the claimant with the proper security. Arrest rules and regulation is different from countries to other countries. There are 2 international conventions who tries to harmonize and uniform the arrest rules and regulations in the world. The first one is Arrest Convention 1952, and the second one 1999. In the first convention, they defined maritime claims, and they named 17 claims, which is called maritime claims, and they said that you can arrest the vessel in case you have a maritime claim. In the second convention, they named 22 maritime claims, and they tried to make a closed list for the maritime claim. And they said that you can arrest the vessel if you have a maritime claim, which is named in the convention, to obtain a proper security. So Iran is not a party to these conventions, so we don't have any definition about maritime claims. Our Iran maritime code actually doesn't have anything about arrest. It is totally silent. How to arrest the vessel, when you can arrest the vessel, so it is silent. Only there is one article which simply says that if a proper security is posted, the arrest should be lifted. That's all. So how we arrest the vessel in Iran? So we look at Civil Procedure Code. There are 2 technical legal tools we can use. One is asking for provisional order or interim order, and the second one is to ask for attachment order. So, which court is competent to issue the arrest order? So the court is competent if he has the competency to hear and to listen the case in merit. So if you have a contractual dispute in which you put arbitration or mediation as a way for dispute settlement, court will not accept to your request for the arrest, because the court will say that, look, you put the arbitration clause, so I'm not competent to hear your case. If we go for the provisional order, and if we got the order from the court, we have 20 days time to file the case in merit. If we go for attachment order, and if we get the attachment order from the court, we have 10 days time to go to file a case in merit. So if the claimant doesn't file a case in merit, then the defendant can go and ask the court to lift the arrest. So arrest in Iran is not very easy. So in common law country, arrest is much easier. So in Iran, because the maritime claim has not been defined, so we can arrest the vessel only if we have a claim against the owner of the vessel. And all documents should be translated to our language, which is called Persian or Farsi, by official translator. And if a document comes from abroad, like if the time that person is giving power of attorney to a local lawyer, the power of attorney should be attested in Iranian consulate in the destination, in the origin, country of origin. And the most important part is deposit. If you want to arrest a vessel, if you have a claim, for example, for $500,000, your claim amount, the court will say that you have to put a deposit in the court to secure any possible damages due to the wrongful arrest or illegal arrest. So the amount of the deposit will be determined by the judge. The hand of judge is open to decide. It is totally under discretion of the judge to say how many % of the claimed amount should be deposited to the court account. Some people are actually saying counter security. So it is compulsory. You have to actually pay a percentage of the claimed amount to the court. For example, if your claim is $500,000, and if the judge says that you have to deposit 10%, you have to pay $50,000 to the court account, and if they say that you have to pay 20% as deposit, you have to pay $1,000 to the court account. So it makes arrest a bit difficult in Iran. So there are some exceptions, which is not directly for the arrest. It is just for generally if you want to obtain arrest or obtain interim order, attachment order, if the claims directly comes from a notarized debt, or if it comes directly from a rejected commercial document like a bonus check, then there is no need for posting any type of deposit. Okay, the owner can make his protest within 10 days of being formally informed about arrest, but actually the arrest writ is neither pleadable in appeal court nor in the high court. The court will review it at first hearing on merit to decide the legitimacy of the protest. So, we reached to the point that we talk about the arrest. Now we want to talk about the release of a vessel. Generally, a vessel can be released if the owner of the vessel pay the claimed amount to the court account, or give a bank guarantee equal to the claim amount in favor of the court. But another option is using letter of undertaking of P&I clubs, which is quick, simple, easy, and also cheap, because transferring of money and giving bank guarantee both are expensive and time-consuming. Letter of undertaking of P&I club cannot be given to the court because court will not recognize it as a security or as a proper security. We can give the letter of undertaking of P&I club to the opponent party, to the claimant, and claimant will go to the court and will say to the judge that we reached to some sort of agreement about the security, and the vessel will be released upon that. And the last point, so arrest is arrest always, whether in sanction time or not sanction time. we are living in a country which is under sanction for years, and we are a major producer of oil, gas, and petrochemicals. So there are so many tankers coming and going to the Iranian ports. We are a major importer of commodities, so many bulk carriers are coming and going from our ports. So arrest is going on as always, but when it comes to the subject of release, the release become very difficult because clubs are not ready to give LOU, so they hesitating to give LOU because the LOU means a financial obligation, so they don't want to give LOU when an Iranian interest involved. And if your vessel, any foreign vessel comes to the Iranian port and being arrested, then clubs are not giving letter of undertaking. The other options are either to go for the cash payment or bank guarantee. Iran is completely isolated. There is no relationship within the international banking system, totally disconnected. So if you want to put security, if you want to pay cash, or if you want to put some sort of bank guarantee, it cannot be done through the international banking system. You have to use the exchange bureaus, exchange houses. So this system makes it more complicated, time-consuming, and expensive. So it means that we are not suffering alone from sanctions. Others also are suffering from sanctions. That's all.
Thank you, ma'am. So our next speaker for Block 7 is Miss Naviki A. Tugwell, who is a partner at Tugwell's law firm, Honduras. Also, she is in registry matters of the purchase, sale, and commercialization of oil and all its derivatives, special regimes, registries and tax exemptions, as well as waivers, maritime affairs, ship registry, real estate and registry, law, trademark, and patent registrations, banking, and corporate law. She's also a law speaker in various organizations and universities. Ladies and gentlemen, please welcome her on the stage.
Good afternoon, everyone. I am delighted to be able to share with you in this great event in which we had the opportunity to enrich our knowledge from the perspective of many countries, which help us have a better vision business development worldwide. Today, I will be talking about international maritime activities in Latin America and regulation approaches. In order to understand maritime activities in Latin America and the Caribbean, and particularly in Central America, it is important to look into trade figures. According to the World Bank, despite pandemic derived from COVID-19, in 2020, the region's international trade accounted for exports of more than $900,000 million, based on approximately 4,000 products and 234 trading partners. Conversely, Latin America imported more than 4,000 products from 236 trading partners, and the important value was almost $900,000 million. For enable all these exports and imports in the Latin America and Caribbean region, Maritime shipping services are crucial. Therefore, maritime shipments play a backbone role in the region's international trade activities. Data from the United Nations Conference on Trade and Development recognize that the COVID-19 pandemic seriously disrupted seaborne trade, exports and imports. During the first half of 2020, the region's trade fell by 12.2% in 2021, including both goods and goods loaded and discharged, amount to 2 billion tons, a 3% increase over 2020. The continent accounted for 12.6% of total goods loaded and 5.8% of total goods discharged at the global level. In this first half of 2022, most Latin American and Caribbean subregions increased their cargo exports. Outlook of international trade activities versus maritime activities in Latin America. After having a panorama of Latin America and Caribbean trade and maritime activities, we can now focus on the region's international maritime law and regulations. To get a background, international maritime law and regulation in Latin America have undergone significant changes in recent years, with the implementation of new rules and regulations designed to ensure safe and environmental sustainable shipping practices. One motor of the modernization of the port facilities is the Inter-American Committee on Ports, part of the Organization of American States. They host a program of activities such as political dialogue, capacity building, technical assistance, and promotes the celebration of public-private partnership alliance. All the mentioned activities are carried with the objective of increasing international competitiveness on the region for facilities and services as well. In addition, the committee is working in the establishment of a technical advisory group on the public policies, legislation, and regulation. Considering all that as business operating in the maritime industry in Latin America and the Caribbean region, it is essential to stay informed about this initiative and comply with all the relevant law and regulation updates. This following graph, made by Safety for Sea, presents you an image of the busy ports in the Latin American Caribbean region. As you can see, Panama is always the most busy port of this region. The international maritime law and regulation in Latin America and the Caribbean are governed by international conventions and treaties, as well as national laws and regulations. The most important of these international conventions is the United Nations Convention of the Law of the Sea, UNCLOS, which was signed in 1982 and has been ratified by almost all countries in the region. UNCLOS established the legal framework for all activities in the ocean and sea, including maritime transportation, fishing, and exploring and exploitation of natural resources. Moreover, its tribunal is based in Hamburg, Germany. In addition to UNCLOS, there are several other international conventions and agreements that regulate maritime industry in the region. The International Maritime Organization, IMO, is the United Nations agency responsible for the safety and security of shipping and the prevention of maritime pollution. They have had developed a number of international conventions and protocols, including the International Convention for the Safety at the Sea, SOLAS, the International Convention of Standards of Training, the Certification and Watchkeeping for Seafarers, and the International Convention for the Prevention of Pollution from Ships, MARPOL. In addition, Latin American countries have implemented other regulations aimed at reducing the environmental impact of shipping. For example, in 2018, Brazil adopted a new environmental law that requires all ships entering in Brazil ports to have a valid international air pollution prevention certificate that verifies that the ship's emissions comply with the IMO's air pollution and prevention standards. Moreover, countries in the region have been taking steps to enhance port security, such as the implementation of the International Ship and Port Facility Security ESPS code, which sets our guidelines for security procedures and equipment at ports. This code was implemented following the September 11 attacks, and all ships and port facilities in Latin America are required to comply with it. Nowadays, there are also many efforts for containing drug trafficking and enhancing maritime container terminal safety due to the increasing intercontinental drug trafficking. Another important aspect of international maritime law and regulation in the region is the requirement for ships to be properly crewed and equipped. The STCW Convention established minimum standards for the training and certification of seafarers, and compliance with these standards is essential for the safe and efficient operation of ships. Coupled with it, the next relevant aspect of international maritime law and regulation in Latin America and the Caribbean is the protection of workers' rights. In many countries, labor laws apply to maritime workers, and they are entitled to the same rights and protection as workers in other industries. The International Labour Organization has also developed several conventions especially for maritime workers, including the Maritime Labour Convention, which sets out minimum standards for working conditions, hours of work, and health and safety. One of the most important aspects of international maritime law and regulation in Latin America and the Caribbean is the requirement for ships to be seaworthy and to comply with safety environmental standards. These standards are established by international conventions such as SOLAS and MARPOL. Compliance with these standards is essential for the safe and efficient operation of ships, and failure to comply can have serious consequences for the business communities, such as fines, detention of the ships, even criminal charges against the ship's owner and operators. From the general work governing maritime industry, treaties, and regulation, it is important to take into account that each country has its own national law and regulation governing the maritime industry. In the Central America region, there exists a central authority grouping all seaports on the region, the Central American Maritime Transport Commission, COCATRAM, which administers all international treaties signed by the country members of Central America Integration System. At the same time, this entity executes projects for improving competitiveness of Central American ports. In Central America, of course, the Panama Channel is from vital importance on the global maritime industry. The geographical location of Honduras gives it privileged position for international trade. It has two coasts, the Pacific and the Atlantic, which make it a strategic point for the entry and exit of goods. Honduras is a strategic sea maritime route in Central America due to Puerto Cortés, the largest and busiest port in Honduras, and serves as the primary gateway for trade with the United States, Central America, and the Caribbean. For the United States case, Puerto Cortés counts with an FDA certification that allows pre-checking products compliance with the US before the products are being loaded and shipped to the US market. On the other hand, Puerto Cortés has modern facilities and handles a wide variety of cargo, including containers, vehicles, and bulk commodities such as grain and petroleum. La Ceiba is another important port of Honduras, handling both commercial and cruise ship traffic. Through the Central American Bank of Economic Integration on the Pacific coast, San Lorenzo is the port serving cargo to the Asian group. The port of Roatan is located on the island of Roatan, the Caribbean coast. It is the most important tourist port in Honduras, receiving a large number of international cruise ships each year. The island of Roatan is known for its beaches and for having the second biggest coral reef in the world, making it a popular tourist destination. In conclusion, compliance with international maritime law and regulations is essential for business operating in the maritime industry in Latin America and Caribbean region. Despite world's latest challenges and conjunctures, the region has implemented several regulations aimed at ensuring safe and environmentally sustainable shipping practices. At the same time, the region is making policy efforts to improve service and competitiveness. Overall, when booking maritime services in the region, it is important to stay informed about regulations, emerging trends, and comply with them. Thank you for your time.
Thank you, ma'am. So, ladies and gentlemen, now let's move on to the next block. On huge demand, this block focuses on laws and requirements of fintech, blockchain, and cybersecurity in various jurisdictions. This session, though, is the last but not the least on the hits and likes of techies, investors, and lawmakers alike. It has 3 solo presentations. So let's dive right in. So for the first presentation, we have Dr. Ulrich Eder, who is the president of Pugnatarius SA, an independent niche advisory firm with headquarters in Panama City, Republic of Panama, established in 2009. This firm is fully independent and with a focus and in-depth knowledge of crypto asset transactions and offshore structures. The firm's clients are crypto millionaires and other investors with a demanding and challenging wealth structure. Let's welcome him on stage now.
Don't I have a? Oh, okay. Yeah, let's start. Okay. Yeah, good afternoon. It's already late, and thank you all for being here, even if the conference is a little bit phasing out. But I have a super interesting topic for you, so I think it's worth your time to be here. Crypto offshoring, you have never heard about it, I know, maybe because our firm, we invented the term, the name. This year, this is a hardware wallet. A hardware wallet to store cryptocurrencies. On this small black box, you can store cryptocurrencies for $5,000. You can also store Bitcoins and other coins for $5 million, and you can even store here cryptos for $5 billion on this small box, and it's super safe. May I ask the audience, who of you is a little bit familiar with a hardware wallet? 1, 2, okay, 3. There are other types of wallets. There's an app, of course, app for everything, we have an app. And there's also a brain wallet. You can remember it, memorize it in your head, and then you can have the $5 billion in your head and take it with you. So, crypto offshoring, what does it mean? Simply said, you have here in your hands safe tokens, the safe bitcoins, and I advise you, you should transfer it offshore, let's say to Panama, where my office is. And what does it really mean? It means crypto plus offshore is crypto offshoring. Yeah? What are cryptos? You have the Bitcoin, everyone knows about Bitcoin. There's a privacy coin, especially Monero. And you heard yesterday already, there is a distinguishment between securities and utilities coins. And there are tokenized assets, so you can have an asset who is linked to real estate. In Dubai, you might be linked to fractional ownership in a yacht in the Caribbean. There are NFT, we talked also about it yesterday, and there are stablecoins that are pegged to the US dollar or other fiat currencies, and there will be soon the cryptos of the government, the CBDC, the central bank digital currency. So we have here our personal wallet here in Dubai or wherever I am with my wallet, and I want to transfer it offshore, let's say to the Caribbean, to British Virgin Island, to Panama, to Vanuatu, or whatever you think about it, to an offshore entity. And if you hear it and you think about it 1 minute, you will ask me, are you kidding? And you will have more or less 4 questions. You say, first, why should I take the cryptos out of my very secure self-custodial wallet, this one, and send them to an offshore location which I don't know exactly? You will also say, in the crypto world, everything is global. What is really the point of offshoring? Isn't this something of the past? The cryptos are stored on the blockchain, where you have a wallet, where you have the keys, it does not really matter. And number 3, you would say, and a little bit about the offshore industry. It's not so easy there. There are certain nominees, which I don't know. There are some nominee directors, maybe nominee shareholders. There are middlemen. There might be some agents that I don't trust. If I'm looking for my investment, for my crypto wealth, why should I trust some person 10,000 kilometers far away, which I never met in person? And number 4, you would say, even if all these disadvantages disappear, what is really then the effect to do this? Why should I do it? And I will try you in the next 10 minutes to convince you it makes really sense to do it. And for these 4 questions, there's a good answer. Maybe I don't have the time to give you all answers to all 4 questions, but anyway, at the end, I have a good answer for all this. Offshore. This slide should be named location, location, location. We're talking about the location. It's really important, but why is it important? First, we look to the blockchain. Some of you might not really understand what a blockchain is. We don't have the time here to explain it. But the question, where is the blockchain, is something where you don't get really a clear answer yet. I can give you 3 answers. Answer number 1 is, the blockchain is away in a foreign country, in a foreign jurisdiction. Answer number 2 is, number 1 would mean it's not here in Dubai. Answer number 2 is, the blockchain is nowhere. It's somewhere, but at the end it's nowhere, so it's not in Dubai. And answer number 3 is, the blockchain is everywhere, so it's also in Dubai. Then you have, the blockchain technology has some persons who maintain it. There are miners, there are nodes. And if you look to Bitcoin, for example, you will see there are more than 100,000 computers which running the Bitcoin code all over the world, in each country, in each city, more or less, more than 100,000 in total. Then we have here the wallet. Maybe I should take the wallet, put it in an envelope, and send it to an offshore location, and the problem is solved. And there's, of course, the holders, like the persons who have the crypto assets. And so there are different questions, different levels. What is relevant for the location? For what is it relevant? If you look to countries like Panama or like Thailand, there the foreign sourced income is not taxed. They just tax domestic income. And the interesting question is this domestic income or is it foreign sourced income because it comes from outside of Thailand, from outside of Panama, outside of Hong Kong, and so on. And then what is the applicable law? Is it because all the persons who maintaining it, they're sitting in the United States. Is it therefore US law? Or is it here Dubai law, and if I go outside, it's other law? How it is governed? And of course, the taxation. Yeah, which taxation rules are relevant on this level with different locations? And we have also the tokenized assets. Let's say you have fractional ownership in a yacht, and the yacht is in the Caribbean. So the question is, yeah, the token is here in my hand. The yacht is in the Caribbean. Which laws are relevant for this? The idea is, and you see here, united we stand, divided we fall, to have a combination of the blockchain advantages and the combination of the offshore advantages. And we say in the blockchain industry, be your own bank. It means you have no real counterparty risk in your investment. Yeah, if you have the Bitcoin on this wallet, then whenever all the banks fail, all the companies go bankruptcy, you still have this. No one can take it away from you. So you are your own bank with all these crypto assets. And what we want to achieve is that you don't say be your own bank, but be your own offshore bank. Yeah, the offshore bank has some advantages, and if you are your own offshore bank, you can make use of these advantages. Oh, as I see the time is running fast. I would like to mention, and I would like you to memorize four aspects of the disadvantages, of the risks of crypto assets in your hand, in your local jurisdiction. And these are, number one, surveillance, number two, the prohibition, the ban, number three, taxation, and number four, sanctions. So, you know, or you don't know, cryptocurrencies, they look anonymous, but they are not really. And if you are a crypto wealth person in some country, I don't want to mention any names, and you know your local tax officer, he knows you have some millions in your hands, some millions of dollars. You might not feel comfortable whether he will knock at your door in the night. And I have clients who have this concern. They say, we don't want to report our crypto wealth because we don't feel safe in this situation. So to avoid surveillance is of big importance. Prohibition. Yeah, I talked about Monero. Yeah, for example, here in Dubai, Monero is illegal. You're not allowed to hold on your wallet Monero coins. You are not allowed to make a transaction with them. And I show you here the picture. I took it from Wikipedia about the Bitcoin ban. You see some countries, the red ones, Bitcoin and cryptos are banned, then there's the green ones. But this is really a work in process. Next year, there might be a different picture, maybe with more red areas, maybe not, we don't know the future. Number three, taxation. You see, if you buy, let's say, a Mercedes-Benz, and you pay with Bitcoin, typically, if you buy something, a car or a house, this is not a taxable event. You don't pay taxes for an acquisition. You don't pay taxes to buy things. So here in this case, the jurisdiction A, they say, okay, you buy it and there's no taxes on it. Then in countries like Germany, where I come from, they say, no, tax-wise, it's a different transaction. Tax-wise, you have to separate it first in a sell of your Bitcoin. So you sell your Bitcoin, you make a taxable profit with it, and then you buy your Mercedes-Benz with cash. Yeah, even if you, in reality, you paid with cryptos, under tax view, you have such double transaction. And there are lots of different tax issues now and in the future. We don't have the time, as I see, to go through it. Number four are sanctions. I left it mainly blank for a reason, for a purpose, and we should not talk about very sensitive things. Yeah? But let me repeat it, because it's really, I would like you to take this home. 4 aspects: surveillance, prohibition, taxation, and sanctions. Okay, and we have it, maybe I should skip it because that I can show you part 2 of this 4-part presentation. The question is how to set up, how about the offshore world? And if you're familiar with offshore structures, you will know it's not so easy. There are certain aspects. You have legal aspects, you have taxation aspects, and you should be aware, at least, there are specific crypto-related aspects which has to be handled to select the right jurisdiction to do the things right. I know that offshore companies are under attack, yeah, and there are increasingly tax regulations. There's a CFC rule, the Controlled Foreign Corporation rule, and the 4 things I mentioned here, no time to go through it. And there are also specific tax aspects. And just to go to the last one, yeah, the buy, borrow, and die method, I recommend to do it. Yeah, buy, borrow, and die. That means you buy the cryptos, you buy the Bitcoin, you don't sell it anymore, but you borrow them for a loan without selling the cryptos, and at the end, unfortunately, you die without having been taxed. And this is what the really rich people are doing. Yeah, buy, borrow, die. So maybe this is the last aspect, but look to the time. If you look to the offshore risks and downsides, yeah, you know you have the nominee, you don't know him, and all this. Is this relevant also for crypto offshore risks and downsides? And the answer is no. Answer is no. Why? Because if you do this as we propose, as we advise our clients, yeah, to transfer the cryptos to an offshore location, into an offshore company, what do you have? Yeah? You're sitting here, you have the wallet in your hand, you have the cryptos in your hand, and so in my case, the Panama company owns the cryptos, but I have a kill switch. That means whenever everything fails, the nominee runs away, the jurisdiction is changed, you still have the coins, you have the private key to the coins, no one can take it away from you, so you are really your own offshore bank in this case. Procedures, what to do? Yeah, there are traditional aspects to set up offshore structures. There are specific crypto aspects. I will have these slides on our website next week, so you can have a deeper look into this. There are, of course, many aspects I could not highlight here. There is a list, what is the best offshore jurisdiction for crypto, and there are very complex tax issues. I worked 30 years as a lawyer and as a German certified tax advisor. Now I'm retired, so I don't maintain any professional license, so don't call me lawyer, please, not anymore. And this is what I wanted to present to you. You got just a keyhole viewpoint on this, and it's not the full picture, but it should give you the idea that this is an attractive idea to consider if you or if your clients really have crypto wealth, crypto assets, and they want to protect it against the future. Thank you very much.
Thank you, sir, for sharing insights. So our next speaker is Ms. Geeta Lakshmi Ramchandran, who is a managing counsel at ABA Legal Consultants. She brings to the firm 26 years of legal experience, supported by her professional qualifications, memberships, and associations. Most recently, Geeta's passionate approach to deliver meticulously precise advice to corporate clients has contributed tremendously to the fintech sector, having advised multiple startups covering an extensive area of research and analytical reports on UAE's cyber laws, cybersecurity risk assessment and management, with a proven drive to decipher UAE cyber laws interpretations with special emphasis on corporate deployment. Ladies and gentlemen, please help me welcome her on the stage.
Good evening, ladies and gentlemen. First of all, many thanks to WLA for organizing this. I'm a little sad and upset about something, if I can be very candid. The subject is so vast and so interesting. I think you need 3 or 4 of these alarms to stop me if I don't stop. On that note, virtual assets and the UAE regulations, well, as all of us would know, it's a evolving law, evolving business interest, and it is one of the top-notch debated subjects all over the world. And there's a lot of work that we lawyers anticipate to do alongside all the governments and regulatory authorities who are stepping up the rules and regulations in relating to virtual assets. So this is just a thanks to the President of UAE, who has taken this up and who has marched forward and has helped us to be one of the countries in the world who have already got a regulation and a regulatory body in place. Now, this is exactly what we wanted to say. Welcome to the UAE. The UAE's march in becoming the first ever country in the world with regards to virtual assets regulation and implementations, including implementing and setting up the Virtual Asset Regulatory Authority, in fact, is evidenced with Binance, Kraken, Bybit, FTX, and such Bitwit, who are all players in the virtual assets scenario. And as far as VARA's evolution is concerned, it was on the 28th of February, 2022, under the aegis of the UAE's virtual assets law, VARA was set up. And VARA's task is mainly to regulate all of the virtual assets. Now, if you see, VARA, as you all would know, they also announced their placement in the MetaV HQ hub in the Sandbox, which is a diverse metaverse built on the Ethereum blockchain as on 3rd May 2022, making VARA the first regulator in the whole world to make it in the metaverse debut. Now, this was the first ever cabinet decision that came into place. If you all are not aware, the UAE is a country formulated with about 7 emirates. We call them emirates. You can remember them as states. And so we have the Securities and the Commodities Authority, who played the role of regulating all of the virtual assets in the country. However, they have taken a few deviations, and how we operate is primarily, as you all would know, we have the Emirate of Abu Dhabi, the Emirate of Dubai, then comes Sharjah, Ras Al Khaimah, and then Al Quwain, Fujairah, and Alain. Now, with these 7 emirates, as you all would be aware, Dubai takes the primary spot of what can you call the most famous city in the world, followed by Abu Dhabi concerning the UAE. And here, if you see, the cabinet decision was actually taken by the federal government under cabinet decision number 111 of 2022. And this clearly explains what is a virtual asset. And they make it as a digital representation of value that can be digitally traded or transferred and can be used for investment purpose. Now, if you see, this is a evolving legal regulation, And therefore, as recently as the 17th of April this month, the SCA announced that all UAE-based companies that provide virtual asset services, except for those licensed to operate in the financial free zones, are required to comply with the provisions of these decisions and file their license applications with the SCA. And the companies operating in the Emirate of Dubai, that's where the VARA comes into place. So the companies operating in the Emirate of Dubai fall under the Virtual Asset Regulatory Authority, which is set up in Dubai. So we need to understand there is not exactly two authorities where a VASP may have to go through, but if the VASP, which is the Virtual Asset Service Provider, wishes to set up here in Dubai, they fall under the Virtual Assets Regulatory Authority in Dubai. And we also have two financial regulating authorities, which is the DIFC in Dubai and the ADGM in Abu Dhabi. Now, they have their own set of rules and regulations, and still are not very clear how that's going to work. But however, we understand that VARA formulates all the regulatory requirements for the virtual asset service providers incorporated and registered in Dubai or elsewhere. And for all the others, the Securities and Commodities Authority come into play. I've tried to make a very simple list of all the list of virtual asset activities which are permitted under the law number 4 of 2022 that regulates the virtual assets in Dubai. The providing services for the operation and management of virtual asset platform, providing services for the exchange between one or more forms of virtual assets, providing services for the transfer of virtual assets, providing brokerage services in virtual asset trading, providing services for the custody and management of virtual assets and enabling control over them, and providing financial services in connection with an issuer's offer and/or sale of virtual assets. This is quite interesting because we have already started receiving a lot of inquiries from several overseas players in relation to setting up themselves in the UAE as a virtual asset service provider. Now, this is very important. As Chad was explaining in yesterday's session regarding the compliance, which has become extremely critical in UAE, in terms of the anti-money laundering and in terms of the anti-terrorist financing protocols, every entity which wants to set up themselves here in the UAE will have to go through a multitude of compliance ordinances, and that specifically is applicable for virtual asset service providers who want to set up shop here in this part of the world. Now, who is authorized? Any entity that wants to be a virtual asset service provider in the UAE must be based in the UAE to conduct asset activities, virtual asset activities in the UAE. They are required to obtain both a regulatory license and a commercial license to operate. You need to understand here that there is a little bit of difference between approval and license. Now, what happens is in certain activities, there has to be an approval by VARA or the SCA. In certain activities, you just have to be licensed by either VARA or SCA. In the later slides, you will see why I mentioned this. Now, the VASP, we call them the VASP, right? The VASPs are also required to meet certain minimum requirements in order to obtain a license from the SCA. They must comply with both UAE federal level anti-money laundering requirements as well as the requirements from the Financial Action Task Force. Now, VASPs and their partners, they should not be subject to any kind of criminal activity or any kind of participation in any criminal cases or whatsoever, either in the UAE or from outside the UAE. So, who is VARA? By now, I hope you would have understood VARA is basically the Virtual Asset Regulatory Authority. It is one of the 5 financial regulatory authorities that we have in the UAE. And their specific establishment is to regulate the complete arena of virtual assets functioning, trading, brokerage, whatever you want to call it, in this part of the world. Now, this is something very important that we wanted to actually share with all of you. There is a slight difference between the definition of virtual assets by the Securities and the Commodities Authority and that of VARA. Now, why is there this difference? Is according to us, VARA has kind of exponentially explained what is the meaning of the virtual asset, and that's how it reads. They're saying the virtual asset has been defined as a digital representation of value that may be digitally traded, transferred, or used as an exchange or payment tool or for investment purposes. So this includes virtual tokens and any digital representation of any other value as determined by VARA. So if you notice here, VARA is the authority which will determine what kind of an asset is a virtual asset that any WASP is trying to trade. And secondly, they are going on to say a virtual token covers a digital representation of a set of rights that can be digitally offered and traded through a virtual asset platform. So this mainly is futuristic in nature, is what we feel, so that any kind of activity that fall under a virtual asset sector will also be covered by VARA. Now, very interestingly here, VARA has very recently released totally 13 rule books, of which 5 rule books are very important, and the remaining 7 rule books relate to actual activity of the service provider, and the 13th rule book is what we call the WAI. So here, if you look at the new VARA regulatory framework that is covering the 13 rule books, is mainly having the following features. First of all, the statutory positioning of Dubai and the UAE as a world's trading hub. And this regulation is actually applying to all virtual asset service providers providing services in Dubai, excluding the DIFC. And these 5 out of the 13 are mandatory rule books, while 7 are covering the activities of the WASP. So the 5 compulsory rule books which you can see, it is rule book number 1 is the Virtual Asset and Related Activities Regulation of 2023, which is very vital. It is available online if anybody would like to go in and see. Then we have the company rule book, which relates to the actual establishment of the virtual asset service providers setup and structures. We have the compliance and risk management rule book. We have the technology and information rule book, and we have the market conduct rule book. Now, these, if you see, are the 7 other rule books, but these are mainly speaking in relation to the kind of services that you want to. Suppose this service provider wants to provide advisory services, like, for example, us lawyers. We want to set up something under VARA as a specific legal consultants who provide advisory services for the WASPs. Then probably we'll have to look into this area. And then you have the broker-dealer services. If that's the service the WASP wishes to provide, then there is this rule book for them. So specifically, if you see, they have created rule books for varieties of activities. We expect this to be expanded more as there will be more business ventures and more needs that will be arising in this sector. Now, even if a company does not fall into any of the virtual activity categories, there are the following kinds of companies that can voluntarily register with the VARA. So these are the companies that are going to be the providers of technological services to the virtual, to the WASPs. And then there are companies that actively invest their own portfolio virtual assets are also expected to voluntarily register with VARA. Now, this is a very important rule book, which is the VAI, Virtual Asset Issuance Rule Book. So this is the 13th one, and we kind of guess this is the most important rule book, because there are some exemptions also in this. If you see, the main criteria that are there in the rule book, whether a VA issuance in the course of business, are as follows. Yeah? Whether the company holds itself out as issuing the VA in the course of business, and the remaining 4, which actually explain what are the criteria VARA is going to focus in relation to issuing of a license. Now, these are the exemptions. 3 of the exemptions, which all of us are mostly familiar with. If the virtual asset is free and non-transferable, if the asset is non-redeemable and non-transferable, and it is redeemable closed loop and non-transferable virtual assets. There is no need really to mandatorily register under as an exemption. Now this is the structure. A WASP is actually expected to maintain a company structure which is clear and transparent, irrespective of the fact who they are. Only one thing that I would like to clarify here, as the compliance protocol or compliance regulatory protocol in the UAE has been imminently, effectively set up, there is no way that a WASP will be in a position to expect being set up without providing for their complete credentials in the UAE. This includes declaring the ultimate UBOs if it is necessary. Even the exemptions or whatever kind of deviation that VARA is looking to take up, it has been amply covered under the aegis of the regulation, where the WASP is expected to identify the shareholders in the form of the license that they have to take. So these are some of the additional information. As I said, we're running short of time. There's some of the additional information that I wanted to really share and tell you that VARA is exceptionally involved with the environmental, social, and governance policies. And there are 3 levels which the VARA actually anticipates the WASPs to comply with. There is a voluntary requirement, there is a compliance, and a mandatory requirement. So mining and staking also falls under the same category. However, the VARA takes a decision with regards to what needs to be the final compliance protocol in that place. So this is our recommendation. We will be in a position to exactly guide you with the structure that is necessary for your risk compliance, as well as the current and future regulatory requirements if an entity wishes to set up shop in this part of the world as a virtual asset service provider. So these are our concluding notes, and we are extremely proud that we are part of a regulatory framework that has been set up even before we are in a position to really trade and practice the virtual asset laws and the systems and protocols. So we definitely have this proud moment where we already have a regulation to follow, and we would be more than happy if there are any inquiries in relation to this, because as of now, as I'm speaking, the VARA has issued only 2 administrative orders. One is in relation to the marketing of the virtual assets by WASPs, and the other one is the penalties and fines. And I'd like to conclude by saying the compliance regulatory mechanism here has a financial penalty imposition starting from 50,000 dirhams until 500,000 dirhams for any kind of non-compliance. And that in itself is difficult for anybody who sets up a license here to see if there are any mediums to deviate from main core legal practice of being a WASP. And secondly, a repeat offense can call forth anywhere between $500,000 to $1 dirham of fines and revoking of the license. So these are some of the, because we are all digitally extremely forward, we have all of the laws covered online and available for all of you if you are interested. So that's it. Thank you very much for this opportunity, and we hope you enjoyed this. We are available for any queries you may have. Thank you.
Thank you, ma'am. That was most informative. So, ladies and gentlemen, now next we have Mr. Chad Altairi, who from Global Strategic Intelligence USA. He's a corporate attorney and business affairs executive in practice for over 15 years, handling public and private equity and debt security financing, international mergers and acquisitions, angel venture capital and private equity financing, project finance, banking transactions, supply chain, due diligence, etc. He is moreover a certified fraud examiner and member of the Association of Certified Fraud Examiners. Ladies and gentlemen, this is the last presentation, so please give a huge round of applause and let's welcome him on stage.
Good afternoon. What better way to end this conference than to talk about money? I spoke to you yesterday about the compliance considerations of importing minerals from Africa, and I touched on the ways in which innovative technologies such as fintech and blockchain can create transparency with supply chain integrity, thus value in global markets through risk mitigation. Well, today I'll expand further on these topics with an introduction into fintech and blockchain technologies and how they can generate wealth. Imagine a world, ladies and gentlemen, where you could securely and efficiently transfer money or assets anywhere without the need of intermediaries, no banks. A world where you could access financial services from your smartphone without ever setting foot in a bank. This is the world that fintech and blockchain are creating. These two technologies are revolutionizing the financial industry, providing greater accessibility, transparency, and security than ever before. They're not just disrupting traditional financial services, but enabling new forms of value exchange and empowering underserved populations. In the span of just a few short years, crypto assets have grown from digital novelties into trillion-dollar technologies with the potential to transform and innovate our global financial system. Bitcoin, with its $500 billion market cap, along with hundreds of other cryptocurrencies, are increasingly held as investments or used as digital mediums of exchange to buy a variety of goods and services all over the world. And even further, imagine a world where all global supply chains shared this transparent and immutable quality, giving the international markets a clear line of sight for trade-based activities and mitigating risk. So, what is the future of money? What is the future of fintech? And what is the future of blockchain? In 2017, a small startup called Everledger, based in London, began using blockchain technology to combat diamond fraud. By creating a digital ledger of every diamond's unique characteristics, including its cut, its carat, its clarity, and its origin, Everledger was able to verify the authenticity of diamonds to prevent the trade of blood diamonds. This innovative use of blockchain technology not only helped protect consumers from fraudulent practices, but it also created a more transparent and ethical diamond trade. In just a few short years, Everledger has expanded its services to include other luxury goods, such as fine wines and art, and has raised millions of dollars in funding. This story not only highlights the potential of blockchain technology to disrupt traditional industries, but it also demonstrates the power of fintech startups to tackle some of the world's most pressing problems. By leveraging technology and innovation, even the smallest companies can make a big impact in the world. So, what is fintech? Short for financial technology, fintech refers to the integration of technology into financial services to make them more efficient, accessible, and affordable. As fintech continues to evolve, we can expect even more changes to the technology landscape, including supply chain innovation. Some of the benefits of fintech include increased accessibility and empowerment, lower costs, improved customer experience, the disruption of traditional financial services, increased efficiency, greater innovation, and of course, blockchain technology itself. So, what is blockchain? Blockchain is a decentralized digital ledger technology that allows for the secure, transparent, and tamper-proof transactions. It works by recording transactions in a series of blocks that are linked together in a chronological chain. It's different from traditional databases in its decentralized structure, its use of cryptographic hashes, its immutability, its transparency, and its security. We thought it can be instructive to give a little brief overview of how blockchain works in case you don't know. It starts with a transaction. A transaction is initiated and broadcast to the network of computers called nodes. A majority of nodes on the network must verify the transaction using complex cryptographic algorithms in order to validate. Once the transaction is validated, it's added to a new block. The block also contains a unique digital fingerprint called a hash from the previous block of the chain, creating an unbreakable link between the blocks. The new block is then broadcast to the network of nodes for confirmation. And those nodes on the network verify the block by solving a complex mathematical puzzle. Once the block is confirmed, it's added to the blockchain. The blockchain is maintained by a network of nodes that must agree on the validity of each transaction on the block, and they usually achieve it through consensus mechanism such as proof of work or proof of stake. Some of the benefits of blockchain include decentralization, security, transparency, efficiency, cost effectiveness, and immutability. Some of the case studies showing innovation and growth in recent years include Ripple, a fintech company that provides blockchain-based solutions for cross-border payments. It also includes Coinbase, a cryptocurrency exchange that allows users to buy, sell, and trade digital assets. Everledger, as mentioned in the opening, is a blockchain platform that provides solutions for asset tracking and provenance verification. Its technology is used to track diamonds, fine wines, and other luxury goods, enabling greater transparency and accountability in supply chain. BitPesa is a blockchain-based payment platform that enables fast, secure cross-border payments in Africa. These case studies demonstrate not only the innovation and potential of fintech and blockchain to transform various industries, including finance, supply chain management, and asset tracking, but also the legal and regulatory matters that require professional attention by folks like us. While fintech and blockchain offer numerous benefits and opportunities, for innovation, there are also several regulatory challenges and risks that must be considered and mitigated. Fintech companies must comply with various regulations related to consumer protection, data privacy, and financial transactions. Blockchain technology is still relatively new, and the regulations are still evolving. The presence of mixers, tumblers, black boxes, privacy coins, peer-to-peer trading, self-hosted wallets all require robust legal compliance consideration. Determining risk appetite, performing risk assessment, determining inherent risks, establishing internal control frameworks, transaction monitoring, customer due diligence, sanction screening, politically exposed person screening, and source of wealth diligence are all regulatory mandates that require specialized work. The inherent risks of fintech and blockchain can be mitigated by implementing robust security measures, hiring experienced legal and compliance professionals, developing standardization protocols, engaging with regulators, building AML, KYC, and sanctions management systems that remain on pace with business growth and utilizing industry-leading regulatory technologies offered by virtual asset service providers. Fintech and blockchain offer numerous opportunities for innovation in various industries. For example, you have smart contracts, which are self-executing contracts with the terms of the agreement written directly into the code. New innovation can automate contract execution and reduce transaction costs for various industries, including finance, insurance, and real estate. Our team here in Dubai is currently working on technology and regulatory solutions to utilize smart contracts to eliminate the needs for letters of credit and blockchain systems for supply chain management, escrow settlement, real estate title, and even probate purposes. Decentralized finance is a financial system built on blockchain technology that enables financial transactions without intermediaries. Regulatory technology uses advanced technologies such as machine learning and blockchain to help financial institutions comply with regulation more efficiently and more effectively. Artificial intelligence and machine learning are also increasingly being used in fintech to improve fraud detection, risk management, and customer experience. As fintech and blockchain technology become more widespread, cybersecurity will become increasingly more important. And one potential area of growth is the use of digital currencies by central banks. Several countries, including China, Sweden, and even the Bahamas, have already started experimented with digital versions of their national currencies. Their so-called central bank digital currencies could offer many of the benefits of cryptocurrencies while still being backed by government and subject to regulation. Supply chain management. As noted, blockchain technology can provide transparent traceability in supply chain management by enabling secure and immutable records of transactions, from tracking the origin of raw materials and ensuring product authenticity and preventing counterfeiting. 24/7 media in fintech and blockchain and in crypto. You know what I think would be great? 24/7 news station covering this evolving minute-by-minute topic and its financial impacts. These innovations can provide greater financial access, transparency, legal and regulatory compliance, and security for individuals and businesses. It can reduce fraud and waste and improve efficiency and effectiveness in various industries. The rise of fintech and blockchain technologies is revolutionizing the financial industry and creating enormous opportunities for innovation and disruption. As we have seen today, these technologies are not only transforming traditional banking and finance, but they're also creating new opportunities for digital currencies, decentralized finance, and supply chain management. As we move towards a more digital, interconnected world, it's clear that fintech and blockchain will play a pivotal role in shaping the future of finance and trade. So I invite you to further explore the world of fintech and blockchain here in Dubai, learning more about these technologies and considering how they may shape future business or investment strategies. The opportunities are endless and the potential rewards are exponential. I asked you at the beginning of this presentation, what better way to end this conference than to talk about money? I do have one. Let's make money.
Thank you so much, Ad, for a wonderful presentation. And now, ladies and gentlemen, we have a short break of 25 minutes. I would request all of you to come back because now, after this, we will reach the climax of the event. And we have the most anticipated Women in Law Awards, for which we all have been waiting for a long time now. So please grab your coffees and get back on time. And I would request the presence of all the participants for this one. Thank you.